Oh, this is fun, because we've been dating to talk so much about Trayvon, and lately now I get to watch people say there was a drug deal at the 7-Eleven, because that's normally, when you're going to drop off drugs, you walk way far away and spend 5 minutes, after walking a mile. Mm-hmm. Very likely, of course, we must consider these possibilities. And these guys are all like thinking, well, I'm being reactionary and I just want to see things a certain way. But in reality, what I'm doing is like, really? You think that's him? Okay, I'll look again. I'm giving you guys the benefit of the doubt. It's not my fault. It's such bullshit. It looks like bullshit when I should look twice. I look twice. And it looks twice as stupid now. Really? 3 times? Now we get to look at George, and we get to wonder things like, oh, is George the kind of person that would make up a story to cover his trail? Is he the kind of person that might harm himself, or think up a cover story, or make up code words, or lie to cops? Why, yes, he is. At least that's what the judge thinks. Order revoking bond. The defendant, charged with second-degree murder, was released on a $150,000 bond on April 20, 2012. At the hearing, the court heard testimony regarding the defendant's financial means from Shelley Zimmerman, the defendant's wife. She testified under oath that she and the defendant had no financial means and should be declared indigent for costs. She acknowledged the existence of a legal fund administered by her brother-in-law, which had collected online donations, but she further testified that she had no knowledge of how much money was presently available in that fund. It was also affirmatively represented that the defendant had turned in his passport. The defendant gave limited testimony at the bond hearing on different matters, but did not contradict or supplement his wife's testimony about his financial resources or possession of a passport. The state filed a motion to revoke bond, which was heard on June 1st, 2012. At the hearing on the motion, the state alleged that, contrary to the testimony provided at the bond hearing, she and the defendant had discussed the amount of money in the fund and how to gain access to it. The state cited excerpts from recorded conversations made at the jail between the defendant and his wife to support its assertion of deception. With regard to we'll get to that in a bit. I didn't bother reading the motion till now. I like to hear what the judge says before you just follow every advocate's thing. But the judge has confirmed this one, so we'll read that next. Huh? It has the actual conversations in it. It's fun. Okay, with regard to the defendant's present financial means, the state notes that they spoke in code to make it sound like they were talking about negligible sums of money. To the contrary, the evidence shows that in the 5 days prior to the bond hearing, approximately $135,000 was transferred from the legal fund into Zimmerman's personal bank account. This was not disclosed at the bond hearing. Also, it was alleged that the defendant was untruthful regarding his possession of a valid passport. At the bond hearing, the defendant surrendered. This is intent to fleece shit. They don't. Oh, he's so stupid. Great when criminals be stupid. Fuck up. Okay, at the bond hearing, the defendant surrendered passport number blah blah blah, which had been issued on May 22, 2002 and an expiration date of May 21, 2012. The defense asserted that this was the defendant's only passport. However, it was later discovered that the defendant was actually in possession of another passport number blah blah blah, which had been issued on March 26, 2004 and expired on March 24, 2014. It was issued as a replacement when the defendant notified the Department of State that he had lost passport number blah 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 that he turned into the judge 8 years later. Ooh, I guess you found it. And then you turned it in. Oh, or maybe you never lost it. Maybe you're a 2-passport one to have, motherfucker, huh? I understand. The state argued against setting a bond for the defendant on the basis that the circumstances of this case demonstrate that he is a serious threat to the community based upon his prior violent history, the repeated refusal to respect law enforcement's directives, and the fact that he is charged with killing an unarmed teenager. Wow, that doesn't sound good. The court, based upon the information presented, determined that $150,000 was an appropriate bond to ensure the defendant's presence in court and also to protect the community. The defendant was also allowed to leave the state and keep his location confidential in order to ensure his personal safety. Had the court been made aware of the true financial circumstances of the bond hearing, the bond decision might have been different. A bond that a defendant cannot afford is tantamount to no bond at all. Good versus Willie, 382, blah, blah, blah. While the court would have been authorized under State versus Arthur, Florida, 1980, to keep the defendant in custody without granting a bond, the court exercised its discretion and set what was believed to be a reasonable bond. In determining the reasonable bond amount, the court balanced the defendant's right to be free from custody while still ensuring his appearance in court with the community's safety if he were to be released. His financial status was a key factor in this balancing test. And then he quotes this law. With the evidence now before the court, the release on bond should be reconsidered pursuant to Florida R. Crim P 3.131S. All information provided by the defendant in connection with any application for an attempt to secure bail to any court, court personnel, or individual soliciting or recording such information for the purpose of evaluating eligibility for or securing bail for the defendant under circumstances such that the defendant knew or should have known that the information was to be used in connection with an application for bail shall be accurate, truthful, and complete without omissions to the best knowledge of the defendant. Failure to comply with the provisions of this subdivision may result in the revocation or modification of bail. Then the judge again. Furthermore, quote, if no conditions of release can reasonably protect the community from risk of physical harm to persons, assure the presence of the accused at trial, or assure the integrity of the judicial process, the accused may be detained. It is apparent that Shelley Zimmerman testified untruthfully at the bond hearing. The defendant also testified but did not alert the court to the misinformation. Therefore, this court is authorized to revoke or modify the defendant's bond. The question then is whether the bond should simply be increased or whether he should be detained on a no bond status. And he quotes, factors to be considered in determining the amount of bail include the nature of the offense and the penalty for it, the character and strength of the evidence or probability of guilt, the probability of the accused appearing at trial, his accessibility to means of flight, his family ties and employment, the length and stability of his residence in the community, the prior record of the accused in responding to process, whether the accused was a fugitive from justice when arrested, whether the accused is under bond for appearance at trial in other cases, his respect for the law, the accused character and reputation, and the state of his health. Among these factors, the only ones that heavily weigh in his favor are that he turned himself in upon the issuance of the original warrant and has kept authorities abreast of his current location. There are several factors that weigh against his release. Listen close, children. This is a serious charge for which life may be imposed. The evidence against him is strong. That's just the judge saying that. He has been charged with one prior crime for which he went through a pre-trial diversion program. I love people who are going, he didn't have a record. Oh, really? The judge counts that. And has an injunction lodged against him. Most importantly, though, is the fact that he has now demonstrated that he does not properly respect the law or the integrity of the judicial process. Based on these factors, this court finds that revocation of the bond is appropriate. And it so is. Oh, yeah, no, yeah, so Zimmerman's the kind of guy that makes up silly codes and stuff. We'll get to that one in a sec. We'll show the kind of thinking this guy does. And you tell me I have to trust him as the only living witness. I don't. The judge doesn't. Nobody has. It doesn't look like anybody is now. Lied right to the court, right after the crime, right? Made a new crime right in front of everybody's face. Meanwhile, you're trying to see things off camera at 7-Eleven. Good luck with that. All right, so here is the motion to revoke bond. Now, this is the prosecutors saying this, but see, I've waited till after the judge says they're telling the truth and approved their motion, or whatever you call it. The state of this is good. Okay, the state of Florida, by and through the undersigned assistant state attorney, pursuant to rule whatever and whatever, Florida Rules of Criminal Procedure, moves to this honorable court to enter an order revoking the defendant's bond. As grounds, the state states, the capital S state, little s states, 1. On 4/12/2012, defendant filed a motion to set reasonable bond. Among the reasons cited by defendant were A, defendant does not have a current United States passport and promises unto this court not to attempt to secure one during the pendency of this matter. Remember that. Defendant has no significant financial assets or savings in that the funds or any bond will come from his family. Hey, I was ready to cut George a break. Yeah, he's starting to get money when people want to help his thing. until I saw actually how he lied about it, and also how the lies are all about him setting up a flight plan. Have $10,000 of cash just on hand, and keep the passport. We're giving him the other one. And he had the 2 passports too for a reason. Why do you have 2 passports? I wonder if the federal government's going to mind about this lost passport that gets turned in as your only passport to a judge. Oh. 2. On 4/20/2012, this court conducted a bond hearing in which defendant was present and several of defendant's family members testified via telephone under oath. At the bond hearing, defendant misrepresented, misled, and deceived the court as to his possession of a United States passport and defendant and his family's financial circumstances. 3. On 4/27/2012, this court held a hearing regarding motions filed by media attorneys. Defense counsel informed the court that at the bond hearing on 4/20/2012, defendant's family members misinformed the court. The state would use a much stronger and accurate word to describe what occurred. Defendant's wife lied to the court about defendant and his family's finances. Defense counsel told the court that the money had now been transferred into a trust account controlled by defense counsel. 4, at the 4/27/2012 hearing, the state asked the court to increase defendant's bond. The court ruled that before it could make a decision, it would need to see who had control over the account, find out how the account was created, and who was in charge when payments were made into the account. At the beginning of the bond hearing on 4/20/2012, defense counsel informed the court that the defendant was surrendering his United States passport and tendered it to the court, noting that the passport expired May 2012. Defense counsel stated, "This is my client's current and only passport, and that he has, and there's a transcript for that. Defendant's United States passport, number whatever, issued in 2002, was introduced into evidence. The defendant was present in the courtroom when this occurred. 6. Nothing could be further from the truth. As detailed in the attached certified records from the United States Department of State Passport Services, the passport surrendered to the court on 4/20/2012 was not the only passport that was issued and available to the defendant. On 5/22, because the motherfucker had 2 passports, because he had lied about losing one, evidently. That's what it seems like to me. On 5/22/2002, defendant obtained the United States passport number whatever, which was good for 10 years and expired in May 2012. See attached United States passport application. This was the United States passport that was introduced at the bond hearing." And you could go, "Well, but he's being railroaded. Of course he wants to be ready to flee." Yeah, and you have a reason to lie, and all I understand all that. You might have a very good reason to lie, and that's why the court will assume you're lying. On 3/8/2004, the defendant filed a claim with the Department of State Passport Office alleging that his United States passport was lost or stolen and applied for another United States passport. See attached Form DS-64 statement regarding lost or stolen passport. The crimes are mounting up. On 4/17/2012, on a call, while defendant was in custody in the Seminole County Jail on this charge, defendant called his wife and spoke to her about his passport. The call was recorded. See attached Seminole County Jail recording. Is approximately 7 minutes into the call. The following conversation took place regarding the passport. Defendant: "Do you know what? I think my passport is in that bag. Shelley Zimmerman. I have one for you in the safety deposit box. Okay, you hold on to that." Shelley Zimmerman for you is the end of that quote. 11. The state has notified the appropriate authorities regarding defendant having an additional United States passport, and they are on alert in case defendant attempts to use the passport to flee the country. 12. The state would request that defendant at a minimum be required to immediately turn over his United States passport to law enforcement if the court needs additional time to rule on this motion. The defendant's financial circumstances at the time of the bond hearing. As defense counsel previously mentioned during the media hearing on 4/27/2012, defendant's family did have access to money at the time this court heard defendant's bond motion on 4/20/2012. During the 4/27/2012 hearing, the court requested defense counsel provide the court and state an accounting for the money defendant had obtained through his website and PayPal records. Defense counsel submitted a letter on 5/18/2012 with documents to this court and copied the state explaining the money defendant had available. Defendant's wife, Shelley Zimmerman, testified under oath at the bond hearing on 4/20 about the family and defendant's financial circumstances. 16. Shelley Zimmerman stated the following. Questioning by Mr. O'Mara, their own lawyer. Lied to her own lawyer. Okay, other major assets that you have which can liquidate reasonably to assist in coming up with money for a bond? None that I know of. I have discussed with you the pending motion to have your husband George declared indigent for cost, have I not? Yes, you have. Are you of any financial means where you can assist in those costs? Not that I'm aware of. I understand that you do have other family members present with you, and I'll ask some more questions of them, but have you had discussions with them of at least trying to pull together some funds to accomplish a bond? We have discussed that. Okay. Trying to pull together the members of the family to scrape up anything we possibly can. Okay, questioning by Mr. De La Rionda. Question. You mentioned also, in terms of the ability of your husband to make a bond amount, that you all had no money. Is that correct? To my knowledge, that's correct. Were you aware of the website that Mr. Zimmerman or somebody on his behalf created? I'm aware of that website. How much money is in that website right now? How much money as a result of that website was? Answer. Currently, I do not know. Okay, the dates. They have the phone calls showing the dates that she did know. Do you have an estimate as to how much money has already been obtained or collected? Answer. I do not. As discussed previously, 17, while the defendant was in custody in the Seminole County Jail, defendant made telephone calls that were recorded. Defendant and the person who he's talking to were aware that the calls were being recorded. During some of the calls to his wife, Shelley Zimmerman, defendant discussed the amount of money sent to PayPal through the website, which was deposited in defendant's credit union account, and at defendant's direction transferred to his wife's credit union account. Even though the defendant was in jail at the time, he was intimately involved in the deposit and transfer of money into various accounts. Defendant was directing the show and used his wife, who willingly participated, to complete the transfers. During 2 of the calls, Shelley Zimmerman is at the credit union, and in one, defendant speaks directly to the credit union official. See attached Seminole County Jail recordings. On 4/12, for those hearings, at approximately 4 minutes into the call, the following conversation took place regarding defendant's financial circumstances. Defendant, take care of my account so you can log in. Shelley, yeah, I know. Defendant, I have $44.46. Defendant, call him so he can reset the password and security question so you can use it. Shelley, yeah. So she had access to the account. Okay, 4:15. At approximately 10 minutes into the call, the following conversation took place regarding defendant's financial circumstances. Defendant, you're going to take out $10 and keep it with you in cash. Less than 10. Shelley Zimmerman, like 9. Defendant, say about 10. I'm wondering you have more than $10, right? Shelley Zimmerman, not with me. Defendant, you don't have access to more than $10 in your account? Shelley Zimmerman, I do. Defendant, I have access to in your account. Shelley Zimmerman, yeah. 4:16, at approximately 1 minute and 40 seconds into the call, the following conversation took place regarding defendant's financial circumstances while Shelley Zimmerman is at the credit union. Shelley Zimmerman, can I put you on speakerphone? Not going to say any personal information since it's recorded. Credit union official, need to reset password now. And then he gets the Social Security. So they know they were at the credit union, resetting the password in the account they had no access to. For just a few days before telling the judge, they're stupid as well. 4:16:12. At approximately 8 minutes into the call, the following conversation took place regarding defendant's financial circumstances while Shelley Zimmerman is at the credit union. Defendant, in my account, do I have at least $100? Shelley Zimmerman, no. Defendant, how close am I? Shelley Zimmerman, $8.60. Defendant, really? So total everything, how much are we looking at? Shelley Zimmerman, like $155. See, that's code for $155,000. 4:16. At approximately 15 minutes into the call, the following conversation took place regarding defendant's financial circumstances. Defendant, if the bond is more than 15, pay the 15. If more than 15, pay 10% to the bondsman. You don't want me to pay $100? Defendant, I don't know. He was anticipating a $100 bond. $100,000. All right, just think about it. Defendant, I will. Shelley, that's what it's for. The court is already aware from Mr. O'Mara 518 letter and documents that the defendant family had access to over $135,000 in cash. The state obtained defendant and Shelley Zimmerman's credit union records on April 2012 and agrees with defense counsel that the amount of money available in those accounts money was also transferred to other accounts. At that time, the credit union statements show on 4/19/2012, the day before the bond hearing, defendant and his wife had access to over $135,000. I don't think that's the big deal. I think the big deal is keep the $10 on you and the extra passport. Okay, yeah, that doesn't have any meaning, right? No, what has meaning is shadows outside 7-Eleven and hoodies. Twitter, that's what's important. Okay, 19. Defendant has intentionally deceived the court with the assistance of his wife, Shelley Zimmerman. During the jail phone calls, both of them spoke in code to hide what they were doing, and defendant fully controlled and participated in the transfer of money from the PayPal account to the defendant and his wife's credit union accounts. This occurred prior to the time defendant was arguing to the court that he was indigent and his wife had no money. In addition, defendant, through his attorney, who I am certain was unaware of what the defendant was doing, represented to the court that he was turning in his U.S. passport. The state is not alleging that Mr. O'Mara was aware of the defendant having a second United States passport, but that he too, like the court, was misled by the defendant, because we got a guy here that lies to his own counsel as well. Or at least we might as well say that. And it's probably true, because there's no way O'Mara would let him do something this stupid. This fucks up the whole court case. This isn't about just a little bit of money. You got a guy that... Defense counsel argued to the court during the 427 hearing in the letter detailing the money transfer that only a small portion of the money was used to secure the bond. Why then was it necessary to lie at the hearing? Defense counsel also argued that all the money that was not already spent was transferred into counsel's trust account. The money still belongs to the defendant and he can demand it at any time. 21. In setting defendant's bond at $150,000, the court relied on false representations and statements by the defendant and by Shelley Zimmerman. The court should revoke the bond or at minimum increase it substantially. And he agreed. Yeah, I think George is looking at not getting out. And as one commenter pointed out, he's already given up the right to a speedy trial. If you get your bond revoked because you lied, it's not like they let you out of... They kept their agreement, which was to let you out if you told them the truth. They're going to make him keep his agreement. I'd rather have a speedy trial than that. Okay. So, yeah.